Week 8 of Karen Reed's trial brought the end of all the testimony, all the evidence, all the exhibits. That's all history now. But what did the attorneys tell the jury in their closing arguments?
Closing arguments have been presented. What happens next? I'm Lainey Law.
And I'm attorney Andrew Myers.
And Andrew, I'm curious as to what you think as far as the quality goes towards these closing arguments.
Well, I mean, we're talking about top shelf attorneys. You know, Alan Jackson flew all the way over here from California, having been hired by Karen Reed. And no matter what you think about Hank Brennan, he's been practicing law for 29 years at this point in Boston. He handled the Whitey Bulger defense, of course. So you've got to give them both credit. You know, it's the first time I ever gave opening arguments in a case. I was up all night pacing around my apartment, there are 18 jurors. That's pared down to the 12 that deliberate. But, you've got to give them both credit for the fact that they did it. And we will ask you at the end of this episode what you thought of the closing arguments. But, why don't we take a look? I took a lot of notes, but I think there's nothing better than actually, seeing what happened in the trial. So it went in the order of Alan Jackson went for the defense first, and then Hank Brennan went for the prosecution, the Commonwealth second. In the first trial, the attorneys were given only an hour, and Alan Jackson pled, I can't do it in an hour. How about an hour and a half? And the judge said, I'll give you each an hour and 15 minutes. So I don't know. I didn't take well to that. I thought that Mr. Jackson, his client faces potentially, if convicted, life with parole, but she could face life, which, at her age in, the mid 40s, come on now. So it's a serious case. That's a serious spectacle hanging over everybody's head. And I would have thought that they should be given more time, but so it was an hour and 15 minutes for both. And like I said before, Alan Jackson went first. And so let's take a look at some of Alan Jackson's closing argument.
There was no collision. There was no collision. There was no collision.
And that's the pattern that he followed for the whole closing argument. You know how real estate agents say there are three things that are important: location, location, location. This was the theme for the whole thing. I thought effective. Some people thought that, it was repetitive, but yeah, you really have to drive the point home.
I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice.
Look at the look on Karen Reed's father, William Reed's face there, all the way on the left. Look at and her mother too. Look at them both. They're just like so concerned. They're almost literally sitting on the edge of their seats.
And say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom.
Notice how he gets Michael Proctor right into the very first minute and a half of his closing argument. I mean, the Commonwealth tried to back away from it when asked. Lieutenant Gallagher and some of the other earlier witnesses had said, oh, well, he wasn't the lead investigator. He was the case agent. It's the same thing. So it's a bold move. I think it's a good move to remind the jury that the Commonwealth is ashamed of themselves. They're ashamed of their lead investigator. They wouldn't even admit that he was the lead investigator. They tried to bury it, but guess what? The lead investigator's been fired for, being biased in this investigating and also for drinking in the police car.
In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us.
Yeah, and that was Kelly Devers, and she made it into this closing argument. She was a popular thing to argue about, and he'll get to that. He gets to a lot of good points here.
At the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty.
What could be going through Karen Reed's mind at this moment while the evidence is in? There's nothing else they can do about getting the evidence into the case. And David Yannetti to her left, our screen right. What could be going through his mind? I mean, does he wish he could have given the closing argument? Does he feel, more could have been made on some points and not others? I mean, what does a guy like that who's been practicing law for 35 years think when, a guy comes in from California to a very good attorney, but he comes in from California to make this argument? What could Mr. Yannetti be thinking?
I just imagine it's like as being an attorney, every time you watch like a case like this, you're probably taking notes for your own self or your own cases and stuff like that. I don't know. I'm curious, I guess, about your experience, you watching this. Do you think that this impacts how you go on further in your future cases?
Oh, you absolutely learn a lot. You absolutely learn a lot. When you first start practicing law, before you even try a case, you go and you watch other people try cases. I remember watching one of the senior partners of the law firm that I worked for in Boston try cases in that very building that we're looking at in the background. Our screen background is the John Adams Courthouse in downtown Boston, across the street from Boston City Hall. And I actually watched the senior partner and others try some cases in that very building. So you do that before you try any cases. Then while you're trying cases, you go to court and maybe your case doesn't get called right away. So you go and watch other people try cases and you hear about, I have a namesake in Boston with a similar name to mine who is one of the big medical malpractice attorneys in all of Massachusetts. And I remember one time hearing that he was actually trying a case. So I snuck into the courtroom and sat in the back and watched them give opening arguments and a couple of witnesses. So yeah, you learn a lot. And even, now, not trying this case, obviously, I would have lost a lot of sleep. Yes, you learn a lot, and you learn about, presentation, pacing, how to, and in our previous episode, how not to cross-examine witnesses. It's a tough skill. It's a tough skill. All of us out here in YouTubeosphere can be very critical of all of the attorneys. But having sat and tried a case in that actual courtroom, you learn a lot. You do learn a lot. And guys like Robert Alessi, who we never heard of before this trial, and David Yannetti, who's very experienced, and Alan Jackson, watching the way they put a case together. Yeah, it's very instructive. It's very, very, very instructive. And I mean, law students that want to get into trial law, not all do. There's a lot of other things that attorneys can do. They do actually go to court and watch cases if they want to learn.
As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain.
And this is a really important point because I think we remember from the first trial, after 3 jury notes, that we had a lot of questions as to whether the jury knew what reasonable doubt meant. And we've had a lot of comments in our comment section that people felt, they didn't think the jury understood what it means and there needs to be a stronger instruction. There is an instruction, obviously, a standard instruction, a pattern instruction in Massachusetts for what does beyond a reasonable doubt mean? So it's very, and the judge is the one that tells the jury about the law, but I think it's correct for Alan Jackson to spend some time, what is reasonable doubt? And you can think that it's likely, but that's not good enough.
I was thinking it's well said. Yeah.
Yeah. It's got to be a moral certainty. I mean, to put someone away for the rest of their life, maybe there's parole, but so I thought it was, really important for him to do that.
Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there.
He's from California. Did he say Canton? Because that's how the locals.
He's training.
Canton. I'll never go to California and do this because they'll make fun of me for how I pronounce everything.
His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen.
Now, in the charge conference the day before these final arguments, the judge instructed the attorneys that not enough evidence had been presented about Brian Higgins or Colin Albert or anyone really being the third party culprit. So they were not going to be allowed, the defense was not to argue the third party culprit theory. However, they could argue about the discrepancies and real issues in the police investigation. So Alan Jackson does a workaround. He does a workaround by spending some time in this opening argument talking about Colin Albert and about especially Brian Higgins. That's why he brought him up there.
That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response. And then we see this.
Here we go.
That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
Now, are they just fooling around? That's the question. Hank Brennan says it's just two guys fooling around. And I think when Jennifer McCabe was asked about that, she said pretty much the same thing, not her exact words, but yeah, guys, guys will be guys. So I don't know.
Do you roughhouse with your friends like that?
Not since I was about 15. When I was 15, yeah, all the time. So I don't know. But Alan Jackson's
Boys will be boys.
Yeah, exactly. But I mean, I don't know. Alan Jackson is telling the jury that, look, there's something there, and there may well be. There's something to be made of this. In fact, when I was 15, the son of the local police chief and I used to get into big fights. If you're watching, sorry, Willie. And it does seem to be a little bit more than just guys being guys. What do you think?
I think that after a few drinks, I think that some people are more likely to even just try to play off like some hidden aggression as like a shove. I think like the physical, I feel like as long as this is going, I feel like is very indicative. I mean, maybe they're playing around, but like I said, like you said, it's just like you don't remember playing around with someone since you were like 15. One, these are supposed to be our law enforcement. Do we want them getting wasted and getting physical with each other? And then also beyond that, I think that it's not unreasonable because you have John and Karen being affectionate with each other when they're drunk. Not to say that drinking is always a manifestation of people's internal feelings, but I could totally see if someone's kind of annoyed, and they're drinking, they might feel a little bit more empowered to give a shove, to give a push. And
yeah, it goes beyond what we're seeing here. Does go beyond a little bit of a push in it. I mean, yeah, sure, you get together with an old buddy. Hey, how you doing? But it's that's all it is. It's like one little push.
Yeah.
This kind of goes beyond that. It really does. And you have to bear in mind that Alan Jackson wanted an hour and a half, and even that wouldn't be enough in my view. But he was given an hour and 15 minutes, and so you, in your mind, if not writing it down in your notebook, which he tends to like to do, every single second of that hour and 15 minutes is so important, because after all these weeks, 8 weeks of evidence, videos, exhibits, testimony, cross-examine, how do you narrow it down to an hour and 15 minutes? So, you have to think that this is a key, important, huge part of the case. And it's part of their theory that, there was more going on than just like, pin it on the girl.
Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John. A gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look.
Too bad there's not audio.
I'm thinking, thank God we got video of this.
Well, in Massachusetts, it is a felony to record a conversation or a voice without permission. It's different states have different rules, but in Massachusetts, it is actually a felony to record someone without getting their consent. You've got to give them notice and consent. And so that's why a lot of, correctly so, security cameras do video only. They do video only. Or if they do audio, they don't tell anybody. And if you request it, they tell you, oh, well, we don't do that. But
if like you have a business and you have a recording on premise and they enter the restaurant, that doesn't protect you.
No, it's got to be consent. It's got to be.
But isn't walking in consent after seeing that sign?
No, it's got to be a positive consent. No. A video, yes. Audio, no.
Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore?
They ignored a lot. So we're going to leave Alan there because he made a lot of good points, not the least of which were that Jennifer McCabe never went in the house that morning when Jennifer McCabe and Kerry Roberts and Karen Reed went over there first thing in the morning on the 29th. Jennifer McCabe never went into the house where her sister lives. And if you go to a house where your sister lives and the body's on the front lawn, wouldn't you go in there and say, hey, sis, what's going on?
What gives? There's a body on your lawn.
Why did Brian Higgins go to the Canton Police Department late that night? If we know that something devastating has happened to John O'Keefe, the first report would go to the Canton Police Department. So Brian Higgins had had a number of drinks. Am I going out on a limb to say the guy was intoxicated? Why does he go to the Canton Police Department? And there's video of him, walking around in the parking lot, moving some cars in the snow. But what was that all about? And then there's Kelly Dever. Don't call me Dever. The whole thing about her working late on a shift, and then her seeing the police chief and Brian Higgins going down into the Sally Port and spending what she called a wildly long time down in the Sally Port with Karen Reed's vehicle. Now, that's kind of weird on a lot of different levels. We'll come back to Kelly Devers in a minute. But the weirdest thing is that if Brian Higgins is potentially someone who could be a witness, let's face it, he could have been a witness. Now he's with the evidence. This is what Alan Jackson said in his closing argument. Isn't that at the very least suspicious that an investigation didn't include him and didn't keep people away from that obvious evidence? Now, Gallagher and others have said, "Oh well, we didn't know." Yes, you did. Any police agency that had half a grain of intelligence would know that if we're going to charge somebody with backing into someone and killing them, that is the weapon and that is evidence. But they said, oh, no, not really. So coming back to Kelly Devers, Alan Jackson pointed out that those were her words, that she did see the police chief and Brian Higgins down in the Sally Port with the vehicle. That's what she said. She said it to the FBI. There's a transcript of it. And then she says, oh, it was a false memory. She can't say she didn't say it because there's a transcript and she said it. And when she was on the stand, she never denied saying it. This is Jackson. I'm just paraphrasing because we have to move on to the next thing. But she did say it. And then she said, oh, it's a false memory. What the heck is a false memory? Yeah, we've had some people in the comments say, oh, there is such a thing as a false memory. Good luck to you. Then the Alan Jackson turned to the Commonwealth's own case against them. He pointed out that in the first trial, and this came into evidence in the second trial, that they put backwards evidence, an inverted video. I don't like the word inverted. It was backwards. And at the same time, they said, yeah, it's a fair and accurate representation. It wasn't. Again, I'm just paraphrasing and summarizing what Alan Jackson had said. He talked about the Commonwealth's witness, Judson Welcher, the Smurf paint guy, and how he was very righteous in his testimony, even though, and Alan Jackson put it out, he was playing dress up as if you looked at Judson Welcher's body language at the time he was doing that test, he did in fact lean into the Lexus. And so, forget that being even a close resemblance of anything that has to do with reality. This is big. Judson Welcher, they're talking about whether or not a vehicle, a 6,000-pound vehicle backing into a man who, okay, he's 6 feet tall and weighs 216, but wouldn't a vehicle backing into somebody have some kind of broken bones? And Judson Welcher said, well, we don't have any x-rays. Well, guess what? They did have x-rays, and the Commonwealth had them in their files for, now 3 years. And he went on, and a lot of good points were made. And the final thing in my notes is that Brennan tried to claim that the holes in the hoodie that he held up in front of the jury, the court, and the witness were caused by the fall down. They were cut by the Commonwealth's own experts. So, Alan Jackson made a lot of good points. He made a ton of good points in his close, and we're not allowed to see the jury, but I would pay money to see the looks on the jurors' faces. Now, sometimes they look like they have a poker face, but I would pay money to see what they looked at. So what are your thoughts, Lainey, as I scrub ahead to the closing argument by Hank Brennan?
I still stand by being really clear on the jury instruction and saying just, if likely, possibly, all of those things are not beyond a reasonable doubt. I think that was a huge I think just in any court case is a huge deal because I think that it's hard to convince someone that, oh, well, this most likely happened. I think that it's hard to remind people that that's not beyond reasonable doubt. So I think that he did a really good, thorough job with that. And I think just overall came off as pretty well spoken and just clear. I mean, obviously, it's a lot to go over, and I can't imagine, like, it's the wanting to do it for an hour and 30 and then needing to do it in an hour and 15 kind of, I find is a little bit funny, but he still did a good job regardless.
I guess there's a balance that has to be reached. I tend to be on the side of the balance that Mr. Jackson and Brennan, to be fair, should have been given more time because this is a very weighty thing. We're not talking about, some simple thing. We're talking about, the life of John O'Keefe, and we're talking about Karen Reed's future, however you feel about her. There are 3 serious criminal charges, one of them being second-degree murder, which Alan Jackson also went into the elements of that. To be fair, I didn't get into all that. It's very technical, but it has to be gotten into. And then Hank Brennan had his turn, and he used a lot more graphics and videos and that kind of thing to the jury. I mean, Alan Jackson used some, but so let's take a look now as Hank Brennan's. Very dramatic. Looks down. Looks at his face. Look at the look on William Reed's face. Look at the look on his face. If looks could kill. Elizabeth Little.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man.
Now, that's all true, and that's fine. But how does that go to any of the elements of any of the charges, second-degree murder or, leaving the scene of an OUI accident or manslaughter? Those are the points that the jury needs to focus on, and he's, it's fine.
Well, even then, and obviously this is a very complicated subject, but to say, oh, he was a good man, he took care of his community. And you know what? None of that implies that he wouldn't want Karen Reed to not be going through this. I mean,
Exactly.
Obviously you can't put thoughts into someone who's not here with us, but even because one, I doubt we're going to be able to prove beyond reasonable doubt that this was intentional. But even if it had been an accident, I don't think that anybody would want their significant other to be put away for life over something like this. So, I mean, I'm not going to say anyone because obviously,
I feel that Mr. Brennan is playing not so much to the jury who he's facing so much as to John O'Keefe's family, who is directly behind him. Just to our right, to his left, you see Peggy O'Keefe, John's mother. And, no matter how you feel about this case, and I've gotten crap from people in the past for saying this, but you have to have compassion for her. I don't care what you think. You have to have compassion for a mother who's lost 2 children now. And it's just, so anyhow, that was my feeling, that he was really playing to them more than to the jury.
Mm-hmm.
He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying.
There's no evidence that none of the medical examiners that testified here said that there was any evidence that he had been hit by a car. So this is closing arguments. I guess you can say in good faith whatever you want. But one of the other people in my office who was watching the closing arguments as they took place yelled out from one office to the other to me this morning that Alan Jackson's closing argument was based on the facts. Hank Brennan's closing arguments were based on emotion. So keep that in mind and tell me if you agree or disagree with that comment that was made to me.
And he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance.
He likes to bang that podium, doesn't he?
Yeah, I don't know. This whole thing is rubbing me wrong, and I can't quite pinpoint what.
If you got the law, bang the law. If you've got the facts, bang the facts. If you don't have either one of them, bang the podium.
And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying.
The debris that wasn't there until after Proctor got the taillight pieces and scattered them there a few days later.
Helpless like a child on the front yard. She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her
I'm
Lexus.
pausing this right here because I am just getting kind of annoyed at this guy right now, where it's like, she didn't call 911. She was the one that could have saved him. She was the one leaving him pissed off voicemails, not knowing what he was doing or where he was at. So I don't know. It's just rubbed me super wrong right there.
You've got to wonder, what the jury is thinking. Court TV, thank you for the video, did a poll. Court TV did a poll immediately after the closing arguments. Guilty, not guilty, or hung jury. 9% said guilty. 82% said not guilty. And 6%, I'm in that category, hung jury. I'm in the hung jury category. But so 9% guilty, 82% not guilty, hung jury 6%. So polls are nice. Polls are great. People do polls. People pay pollsters to, give them the results. But in this case, it's got to be unanimous. There's going to be 12 deliberating jurors of the 18 that listen to everything. It's got to be unanimous. If it's only 82% not guilty, that doesn't do it. That doesn't do it. So anyhow, I just thought that was interesting.
She drove away.
Look at Jim, the court clerk. It looks like he's falling asleep.
She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking at McCarthy's with John. She was drinking at the waterfall. Her blood was taken.
So were the
samples
cops.
of the retrograde analysis.
What'd you say?
No, I said so were the cops. It's like she was drunk, she was drinking, and it's like every other cop in the area was drunk and driving around too. Well,
it's kind of a deflective technique. It's kind of the same as after the defense team, when the Commonwealth rested its case, the defense team brought what's called a motion for a required finding of not guilty. And the defense team went through the fact that there was no real evidence of actually a collision, which is central. There's got to be a collision for any of these charges to stick. And rather than centrally addressing that, Hank Brennan, in that motion argument really hammered down on the drinking, the intoxicated, the test at the hospital. There are two ways in Massachusetts under Massachusetts law to prove drunk driving. One is by an actual blood alcohol or breath alcohol test, lending credence to whether or not the blood alcohol is 0.08 or over. But the other way is to just show signs of impaired driving. So he spent a lot of time explaining that both in the argument that he made against the motion for a required finding of not guilty, but also here to the jury, to kind of deflect, to really hammer home, if you don't have the law or the facts, you kind of, comment on what you do have. And we kind of have, a fair amount of indication that there was drinking that night. Yeah, okay. Give us something else.
Almost 2 to 3 times the legal limit, she was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die.
The hair that was there 3 weeks
He had a basal
prior.
skull fracture, Cantoncoverup, you heard all of it.
I'm sorry?
I said the hair that was there 3 weeks prior. It could have just been there from whenever.
Well, they're boyfriend and girlfriend. So, wouldn't his hair be on her car anyhow? They went to the beach and loaded stuff in and a hair falls off your body, or they go to the grocery store and they've got to make 6 or 8 trips back and forth, throwing the groceries in the back of the SUV, and, your hair naturally falls out anyhow. So that's I don't think that one of his hairs was on that vehicle is probative of anything other than that the fact that he'd ridden in his girlfriend's car a million billion times in the 2 years they were together. That's A. And then B is that SUV had been driven from 34 Fairview over. She drove it to John's house, spent the night, then came back, and then she drove around some more. Then she drove down to her parents' house in Dighton in a blizzard, and a blizzard involves wind. And so, she's driving the thing around. How does the hair stay on the back of the SUV? Come on. Are you serious? I mean, come on now. Let's be serious, Hank. Give us something else.
About it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die.
Look closely. Is Adam Lally playing with paper clips again today? No, I guess he's been told, put the paper clips away.
She was drunk.
He really harps on that.
And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described for you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word. never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface.
This is where the adversarial system that we have, and it's the best in the world. I will vouch for the American judicial system. I don't care what anybody says is the best in the world, but this is where the adversarial system really fails. I mean, one side says, oh, they were all lovey-dovey and, they were doing really well and they were hugging. And then the other side says, look at those, voicemails where she was saying, you're a this and you're a that. So the whole system really fails. And it all comes down, I know. Comment down below what a horrible person I am. I'm not analytical enough, but it all comes down to credibility. That's what it comes down to. What do you believe? So I guess my point is that in our adversarial system, one side goes to one extreme, the other side goes to the other extreme, and the jury is left shaking their head going, oh my gosh, what am I supposed to do here? And
I just think about the jury in the sense that, not saying that the collision, or if there was a collision, that it would be intentional, but I think about past relationships I had, and when I would completely lose it, and it was because my partner was doing something ridiculous or doing something terrible. So obviously, what happened to John is terrible, and we're going to see what the jury decides happened, but I don't know. It's just like saying like, oh, she was this crazy. She was smashing on the door, da 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 da. It's just like, maybe it was because she really cared about him and he was being not the best, and that in those situations where you're freaking out and you want to yell at your partner, it doesn't mean you want to hit them with your car. Or sometimes it means you're angry because you want better for them.
No, people have fights all the time, and you go out, you take a walk, you cool off, or whatever, and it's just like, it's just not there in my mind. Now that's my mind. I don't know, but a lot of times when we have, I did a lot of criminal in my earlier years. Now I tend to do almost all civil, a little bit of criminal, but almost all civil. When we have settlement conferences, or in the old days when I did do a lot more criminal, when you sat down with the DA and you talk, if you couldn't agree about something, the way you would refer to not being able to resolve it amicably and putting it to the jury is, it's up to the roll of the dice. And ask any trial attorney, they'll tell you that's what they say. That's what going to the jury is. It's a roll of the dice, because you don't know. You just don't know. Now, I'm not faulting anybody for taking the case to trial, because you have to take a case to trial in this instance. You can't plead out to anything when the charges are as serious as this. But anyhow, we'll listen to a little bit more of this, then I'll summarize it, and then we'll let it go to the jury.
They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them. You saw them. This relationship.
Look at Clerk Jim. Look at Clerk Jim.
I was thinking
He just
about
wants
that
to.
Before.
He wants to take a nap. He really does. He's had it.
It's Friday.
Relationship was unstable and at its end.
And Adam Lally is looking down. Are there any paper clips for me to play with?
And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So Keefe drinks a lot, and Karen Reed drinks a lot. You've seen.
They all drank a lot.
In the McCarthy videos, you can call it 6, 7, 8, whatever you want to call it, you can see the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober? And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. but they were friendly. There was no adversarial relationship. There was no anger between them.
I don't know about that. I mean, you kind of convinced me. I started out thinking, yeah, it was kind of just guys being guys, but I don't know. There was more than just guys being guys in that scuffle. Don't you think that we just saw during the defense opening argument, closing argument?
Mm-hmm. Well, I guess a little tangentially related is he said Higgins was not honorable, and that gave me whiplash to the whole Proctor, like, doing his job properly, honorably, whatever it was. It's just not a good look.
So Mr. Brennan, in fairness, went on and he went through some more of the facts that at 12/24/33 on January 29th of 2022, that's when the vehicle got there, according to their timeline. Then at 12, they sat and they talked, apparently. Then at 12:31:56, this is the first time John O'Keefe moved. He moved for 20 seconds. That will be the last time that he moved in his life. The location data shows that Mr. O'Keefe never moved again. There was only 20 seconds of moving, and then it happens. That's what Mr. Brennan said. And then something that's very important for a prosecutor to do is to tell the jury how, in God's name, after 8 weeks of testimony, can you put it all together? I mean, you don't just sit in a room and argue and throw things at each other. No. And so he went through the elements of each offense. And we'll just take a look at second-degree red rum. It's spelled the other way around in the actual law books in Massachusetts. Every state has their own statutes and their own laws. But in Massachusetts, Mr. Brennan pointed out to the jury that in order to find Karen guilty of second degree, he never said in the opening that he would prove that she intentionally did away with Mr. O'Keefe, because that's not what the law is. What he said is hitting the accelerator in reverse and creating a strong likelihood of death that allows one to find for second degree. So he pointed out three of the key elements of second degree that the jury has to find. And this is instructive. A, was Karen Reed drinking? B, was there conduct that shows wantonly and recklessly creating a likelihood of serious injury? In other words, when in his view, and if the jury finds that she did back up the Lexus SUV towards Mr. O'Keefe, whether she realized that he was back there or not, is that act creating the likelihood of serious injury? In other words, is she creating a risk of serious injury? That's all they have to find. Is she creating a risk of serious injury? Intent is not an element, or that's the level of intent that's required. And then for the crime of leaving the scene of an OUI accident or a drunk driving accident, the element they have to find is, did she leave the scene? In any event, he pointed out that she left fragments of tail light all over the yard. That is certainly in dispute. He played a lot more clips of the videos and voicemails than Alan Jackson did. He played the John, I effing hate you voicemail. And he pointed out that the data, the case is all about that data and the science and all of that. So there was a lot more to it, but in a relatively brief end of the week summary, which is what we've been doing in this case, I think that pretty much does it. And so my closing thoughts are, I know people on both sides of this, and I know a lot of people say it's going to be not guilty. And how can anybody else, side with that? I mean, I agree with you, but there are a lot of people that don't. I see it down in the comments. I talk to people during the week, and people say, how can it be? I mean, and as Ronnie, the juror, said in his 3-hour interview with Aiden Kearney, well, she was there, he was there. We felt that neither one of them went in the house, and everything else was a distraction, so they're guilty. So, the definition of insanity, according to Albert Einstein, is doing the same thing over and over again and expecting a different result. Now, to be certain, both sides kind of changed their strategy a little bit in the retrial. They did change their strategy. Hank Brennan, cut out some of this, the McAlberts going on the stand. And Mr. Proctor has since been dishonorably discharged. So prosecution side was different. The defense side was different. The last time they only had, I think, 6 witnesses. This time they had a lot more witnesses. So they changed their attack, their strategy, their approach. But it's basically the same case. So I don't know. I don't know. My prediction all along, and people disagree with me all the time, my prediction has been mistrial in 5 days. Lainey Law, do you have any closing thoughts for us before we head out?
I hope that if they land on a mistrial, that it's at least before 5 days. It's just, like you mentioned before with the poll, how it said like 8% guilty, and then the majority thinking not guilty, and then a portion thinking mistrial. I just can't imagine what's going on in that jury room, because I think that there are people, like when I look at the comments on the live streams of the court case itself, you just see so many people saying, she's guilty, lock her up. And the way that I'm interpreting everything that happens is so different than some of the commentary I see online. So it's really hard to determine what is actually going to happen. I would ask our commenters down below to comment on whether or not they think she's going to be found guilty, not guilty, or if it's going to be a mistrial in 5 days or 3 days. At the time of recording this, at the time of these closing statements, it's Friday. So where are we going to be on Monday? Where are we going to be on Tuesday? Where are we going to be on Wednesday? So we look forward to hearing what you guys have to say. So as usual, if you made it this far into the video, please be sure to like this video, comment down below what you think, and subscribe if you're not subscribed already. We have a fireworks show coming up to celebrate 20,000 subscribers. So that's going to be very exciting for the 4th of July.
2 more things I have to say before we hit the close button, and that is that, it really strikes me, it irks me. And even Judge Cannone said that when she was a practicing attorney, and by the way, when she was a practicing attorney, believe it or not, she was a defense attorney. Judge Cannone was a defense attorney, and she told the jury before the closing arguments that she never liked it when judges said the following, but by law she had to say the following, and that is that the closing arguments are not evidence. You are only to consider the evidence that was given to you on the witness stand and through the exhibits. And so the jurors were told you may not keep notes, and their notebooks were taken away. So where they've been, most of them, I guess one hasn't, most of the jurors have been assiduously taking notes for the last 8 weeks. They were not to take any notes during the closing arguments. And the judge, I do agree with her on this. The judge said, it always irked me when a judge in a case that I was trying said this, but that's the way it is. And I understand that intellectually, and as an attorney, I understand that. But on the other hand, it kind of ties it all together. I mean, if you listen to both, you listen to Alan Jackson and then you listen to Mr. Brennan, it just helps you kind of in outline form put it all together. It's kind of like, I won't speak for anybody else, but when I was in law school, you get thrown a lot of stuff. You're asked to read 200, 250 pages a night. Now, at the end of a semester of 8 weeks or whatever it was, how do you remember all of that? So we would go out and buy outlines. We would run down to the bookstore, and we were all told not to use the outlines, but they sold them in the bookstore. So the outlines kind of helped us put it all together, and that's the equivalent of what the closing arguments are. So that's kind of hard for me to take, that they aren't allowed to at least, make bullet points out of the closing argument. Be that as it may, good news for Mr. Kearney. He was found not guilty on the first of the charges that he faced. He's not out of the water yet. There are a few more, but he was found not guilty of violating one of the restraining orders that was slapped against him. So congratulations to him. His administrators used to let us post our episodes on his page. I think somebody in there doesn't like us because they don't do that anymore. But anyhow, congratulations to Mr. Kearney. He recently also got 100,000 subscribers. That's our goal. We'll get there. So let us know how you feel about it. Do you think the jury should have been allowed to take notes during the closing arguments? And we'll update you as soon as the jury comes back. We are in a jury verdict watch, and we'll come back with some kind of an episode as soon as they reach a verdict. So thank you for watching. Have a good one. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.